like to be here at UC, and may also join you in acknowledging the number of people, and I pay my respects also to their elders, past and present. Ladies and gentlemen, the Australian Constitution is a cumbersome beast. Some have said it serves us well, and perhaps that's a legitimate claim in its context. Others have not been served so well by the nation's foundational instrument. It has not been too kind to the rights and interests of Aboriginal and Torres Strait Islander peoples. And many are now saying we need a constitution for all Australians. The panel of experts that was vested with the responsibility of going about Australia to talk to people about the constitutional recognition of Aboriginal and Torres Strait Islander Australians has now presented its report to the federal government, and a response is much anticipated. Just to remind you, the mandate of the panel was to lead a broad national consultation and community engagement program to seek the views of a wide spectrum of the community, including those who live in rural and regional areas. It was also to work closely with organisations such as the Australian Human Rights Commission, the Congress of Australia's First Peoples, and Reconciliation Australia, who had existing who have existing expertise and engagement in relation to this issue of constitutional recognition, and also to raise awareness about the importance of Indigenous constitutional recognition, including identifying and supporting ambassadors who will generate wide public awareness and discussion. And in performing its duties, the panel had to have regard to the key issues raised by the community in relation to Indigenous constitutional recognition and the form of constitutional change, an approach to a referendum likely to obtain widespread support, and the implications of any proposed changes to the Constitution, and finally to have regard to the advice of constitutional law experts, and I'm not one of those. As I said, we're waiting on a response from the government, but what did the panel recommend? Well, there are 5 key things that I want to emphasise today. Firstly, the removal of Section 25, which currently contemplates the possibility of state laws disqualifying people of a particular race from voting in state elections. The removal of Subsection 26 of Section 51, which currently allows the federal government to make special laws for peoples of any race. Insert a new Section 51A to recognise Aboriginal and Torres Strait Islander peoples, and to preserve the Australian government's ability to pass laws for the benefit of Aboriginal and Torres Strait Islander peoples. The fourth thing they recommended that I'm interested in was to insert a new Section 116A prohibiting racial discrimination, which is the central point of today's lecture. And finally, to insert a new Section 127A recognising Aboriginal and Torres Strait Islander languages and confirming English as Australia's national language. And finally, the panel recommended the government carefully consider the advice of the panel on how to achieve a successful referendum. And this, of course, is crucial. Is a crucial question posed by this forum, what I'm meant to be talking about today, which I haven't got to yet. And that is, where do we go next? But I want to come back to this question a little later, because what I've been asked to address today is the potential for the Australian Constitution to prohibit racial discrimination. You can't address or have a discussion on this issue unless it involves an examination of Section 25 and Subsection 26 of Section 51. These two sections were, up until 1967, Section 51 and Subsection 26 and Section 51 and Section 127 prior to 1967 was the only places in the Constitution where there is any reference to Aborigines. Torres Strait Islanders were never mentioned. In Subsection 26 and 51, we were the Aboriginal race, and in Section 127, we were the Aboriginal natives. And each of these references were ditched by referendum in 1967. And as I mentioned, the expert panel recommends the ditching of Subsection 26 and 51 and Section 25. Both these sections, 26 and 51 and Section 25, contemplate discrimination on the basis of race. 25 by the states and 26 and 51 by the federal parliament. Now, the notion of race has been pretty much discredited. Race is, in biological and scientific terms, meaningless and defunct. As one commentator says, it is man's most dangerous myth and is thoroughly and dangerously unsound. He was saying that in the 1930s, so hence no mention of women. So when I'm looking at these provisions, it made me wonder, where did they come from? How did we come to have Section 25 and 26 and 51 in our Constitution? And of course, Section 25, which allows the states to ban people from voting on the basis of race, has never ever been used. It seems to serve no real purpose except to embarrass us. Some years ago, and I want to have a look at one particular character, but I'll be mentioning some others. in the lead up to Federation and the development of our Constitution. But some years ago I had to do some work, had cause to do some work on Sir John Quick, one of the fathers of Federation. They're all men. I don't know if they're all fathers, but they're all men. They all tended to have beards, and women were nowhere to be seen. But in October 1893, John Quick established the Bendigo Federation League and was its president for its only known active years, 1893, 1898 and 1899. Its sole purpose disappeared in 1901 once the Federation was achieved. What my research revealed to me was that John Quick was part of a group who at the 1893 Corowa Conference successfully got a resolution adopted that finally wrenched away the question of federation and the development of a constitution from the colonial politicians in the parliaments of the colonies and handed it over to the people of those colonies. And Sir John was he wasn't Sir John then, he didn't become Sir John until 1901, but he was a delegate of the Bendigo chapter of the Australian Natives Association. Now, the Australian Natives Association were not Aboriginal or Torres Strait Islanders. They were European-born Australians, and generally Anglo-Celtic. He represented the Australian Natives Association. He was born in Cornwall in the UK, and he attended school in Bendigo. And at 10 years old, he was sent out to work in a foundry, and later worked as an assistant to the Bendigo Evening News. He also worked in the Bendigo Independent as a junior reporter, and history tells us he learned shorthand and managed to further his education. He moved to Melbourne in 1873, where he matriculated and then went to Melbourne Uni, where he studied law and was admitted to the bar in June 1878. And it's alarming, perhaps for some, that many of the delegates to the conventions in the 1890s were lawyers. I think our first three prime ministers were lawyers. Not that I've got any hope of being one of them. Prime ministers, I mean. After he joined the bar, he still continued to act as a journalist, and later became the leading parliamentary reporter at the Age newspaper. One of the other aspects of his life that fascinated me was the fact that in the same year he was knighted, 1901, he and Sir Robert Garran, and only a lawyer can get excited about this, but they together published the annotated Constitution of the Australian Commonwealth, described as a monumental tome, including a valuable history of the Federation movement, which of course confirmed his and Garran's authority on constitutional questions. I think it's over 700 pages long. A doorstop and nothing else. Just allow me for a moment to talk about the ANA. The Australian Natives Association was founded as a mutual society in 1871 in Melbourne. It played a central part in the push for the federation of the former colonies into a Commonwealth. And by 1900 had a membership of 17,000 who were mainly located, 17,000 people who were mainly located in Victoria. And it provided sickness, medical and funeral cover to its members. And membership was restricted to Australian-born men of European origin. Indigenous men and all women, black or white, need not apply. It's a boys' club. John Quick wasn't Australian-born, as I mentioned earlier, but the ANA accepted him as a honorary member nevertheless. And in the 1890s, early 1890s, was the first time Australian-born men of European ancestry became the majority population, male population of the country. And in 1880, the ANA committed itself to the Federation of the Australian Colonies and provided much of the organisational and financial support for the Federation Leagues, which led the campaign, particularly in Victoria. And I mention that because this is a lesson for us, and a lesson we ought to learn, not just from the Federation and the conventions and the organisations and the people involved, but also lessons we can learn as to why the 1967 referendum was so overwhelmingly successful, and lessons that we ought to put into practice with this referendum on the recognition of Aboriginal and Torres Strait Islanders in our constitution. Now, when the Victorian Parliament considered the Federation Bill in 1893, it was the ANA which organised the public meetings around the colony and to rally support for the bill. And after the bill failed in the Parliament, it was the ANA which kept the federal issue alive. And it was probably that failure in 1891 that prompted people like Quick to get the business of federation out of the hands of the politicians. That's another valuable lesson we need to learn. And they campaigned vigorously for the referendum, for referendums in each of the colonies to approve the proposed constitution. And after the federation was achieved, the ANA withdrew from political activity, although it continued a patriotic activity of promoting things such as the observance of the Strait. And significantly also, they're one of the first organisations really in this country that also continue to support nationalistic issues such as the welfare of Aboriginal people. And it continued to prosper as a private health fund until 1993, when it merged with Manchester Unity of Victoria and later to create the company called Australian Unity. So what's this got to do with Section 25? Well, let me try and explain. John Quick, MLA, was the member for the seat of Sandhurst, centred on Bendigo, in the Victorian Colonial Parliament. Bendigo, of course, was a gold mining town and contained large numbers of Chinese miners who were then, in Victoria, permitted to vote in elections for the Legislative Assembly in the colonial parliament. Now, Quick agitated the levelling of a poll tax on the Chinese miners as the means he thought that would prevent them from entering the country. Now, in the ensuing election, Quick, a candidate for the Legislative Assembly, the Chinese voters turned against him and he almost lost his seat. On his return to Parliament, he attempted to get passed the first bill for the disenfranchisement of Chinese voters. And he also agitated against the influx of Chinese, again urging the creation of a poll tax as a preventative measure. After that term, he left the Victorian Legislative Assembly. It seems primarily because of a dispute between the then leader and the ministry and his desires for a particular ministry. And he dedicated his, as I've outlined, work to federation. And he was elected to the new Federal House of Representatives as a member for Bendigo. Quick, of course, was a man of his times, and although he supported laws to keep out the coloureds, he said once they were here, they should be treated fairly. And in those days, coloureds didn't seem to include Aborigines and Torres Strait Islanders. And at Federation, both Queensland and Western Australia had laws that, amongst other things, prevented Aboriginal men, amongst others, prevented Aboriginal men from voting. And in the conventions, they said that this 25 was designed to penalise those states who prohibited persons of any race from voting by reducing their federal representation. But Section 127 effectively nullified this result. Section 127, in simple terms, says if you don't get counted, you can't vote. So 127 is about the census. So to get the franchise, you've got to be counted. And you've got to be counted to be voted, to allow you to vote. And additionally, if Queensland and Western Australia could not count their natives amongst their population, they got fewer seats in the lower house, which of course suited both Victoria and New South Wales, the most populous states in terms of Europeans, because they had fewer natives to count. So it seems to me that Section 127 was more about parliamentary numbers than discrimination. But let me return to subsection 26 of 51. Now, it said the origins of this section arises in the original draft of the Constitution Bill of 1891, which purported to empower the Commonwealth Parliament to make laws for the affairs, I'll quote exactly from the 1891 Bill, the affairs of people of any race with respect to whom it is deemed necessary to make special laws not applicable to the general community. And the section went on to say that the Aboriginal native race in Australia and the Maori race in New Zealand were not to be included within this power, which is where subsection 26 ended up until 1967, although there was no mention of the Maori. In the original Federation conventions, New Zealand was variously represented, and at some point they disengaged and determined not to join the Australian Federation. Now this clause that I've just recited was proposed by the first Australian Chief Justice, Sir Samuel Griffiths. And he said he'd proposed it because he was worried about the influx of coolies from British India, or Eastern peoples, namely Asians or Asiatics as they called them then. Eastern peoples who were subjected to civilised power, namely European colonisers. And he seemed to have some distrust of, in the National Parliament, having this power. And it therefore was, from his point of view, better to entrust this, it to the states to deal with these issues, to pass such laws, to regulate the affairs of people of any race. Edmund Barton, the first Prime Minister, thought the Federal Parliament should have the power to regulate the affairs of people of coloured or inferior races who are in the Commonwealth. And he said that, I don't think either that the doctrine of the equality of man was really ever intended to include racial equality. There is no racial equality. These races are in comparison with the white race. And I think no one wants convincing of this fact. They're unequal and inferior. The doctrine of equality of men was never intended to apply to the equality of the Englishman and the Chinaman. There's a deep set difference, and we see no prospect of it ever being effaced. Nothing in this world can put these two races upon equality. Nothing we can do by cultivation, by refinement, or anything else will make some races equal to others. Now, I think the third law passed by the Federal Parliament in 1901 was the Immigration Restriction Act, which entrenched the White Australia policy, really, which didn't get totally dismantled until Gough Whitlam came to power, and he did that in 1973. But this passage I've quoted from Barton was his speech, was out of his speech speaking in favour of the bill to establish the White Australia policy. So, wonder how Barton feel telling the Chinese about that now. Now, Quick and Garran, in their annotated constitution, which I mentioned earlier, said that the race power, and I quote again, enables the Parliament to deal with people of any alien race after they have entered the Commonwealth, to localise them in defined areas. Let me repeat that, to localise them in defined areas, to restrict their migration, to confine them to certain occupations, or to give them special protection and secure their return after a certain period to the country from whence they came, end quote. And I think I now know where this wacky stuff about black people our present day politicians toy with. I now know where it comes from. Now it seems clear to me with this bit of a potted history I've tried to elaborate, that this section, subsection 26 of 51, has never ever meant to apply to Aborigines and Torres Strait Islanders. We simply weren't on the For example, we simply weren't on the radar at the constitutional conventions of the 1890s. We were simply invisible. And our attempts to fix the shortcomings of this omission in 1967 were simply exacerbated by the problems, because subsection 26 of 51 was never meant for us. And as a result of 67, we were captured by its discriminatory aspects. So the goodwill of the people of Australia in 1967, which sought to include us in the Constitution, was sadly misplaced. And now the Commonwealth has, and they have used the power, but they have the power and have further excluded us and marginalised us, not only by the Parliament. This power isn't only exerted by the Parliament, but it's also interpreted by the court. And both the Parliament and the court have worsened the situation for us in respect of racial discrimination since the 67 referendum. Because this power was always intended to give the Commonwealth the power to do what the governments of the colonies have been doing all along up until 1900, namely to discriminate against anyone coming to the colony who was not British. You know, one of the ironic things I find about this is that on Federation, or prior to Federation, but when Federation occurred, all Aborigines of this continent had been previously deemed to be British subjects, but we didn't enjoy the rights as British subjects. So I need to wind this part up because I think I'm running out of time. But it shouldn't be forgotten that not all of our fathers of Federation held what we might think of today as being outrageous views. Quicks, Charles Kingston and Josiah Simon, they wanted to keep coloureds out of the country, but they said once they were here, they should be treated fairly and enjoy all the rights and privileges of Australian citizens. In fact, Simon's stated the following. He said, it's monstrous to put a brand on these people once you admit them. It is degrading to us and our citizenship to do such a thing. If we say that they're fit to be admitted amongst us, we ought not degrade them by putting on them the brand of inferiority. And that was in opposition to this clause at the convention debates in 1898. So that's a bit of a background of where and how we got to these provisions and some of the folk involved in getting us there, and some of the impact of what those sections mean to me and why we need to address them. So the question for us now that I mentioned earlier, where to now? What do we need to do to succeed or to make it happen, to get Aboriginal and Torres Strait Islander peoples recognised in this Constitution? And we know in concrete terms what the expert panel has said. Basically they said there's some words we need to delete and there's some new words we need to add. Simple. Let's do it. If only it was so. And also we need to address, in trying to get this, the recommendations of the expert panel adopted, we need to explain to ourselves why it's necessary to do it. That's the first thing. Why are we doing this? Well, simply I can say it's the right thing to do. I have a bit more elaboration of this in my paper, but I won't go into it right now. But what needs to be what we need to do to achieve a successful referendum, and learning from history, and at least three things I've mentioned in our history that could help us. The panel had largely accepted the approach of Williams and Hume on a recipe for a successful referendum, and they say the following key elements have to be present to achieve that. Firstly, bipartisan support. Secondly, genuine popular engagement or ownership by the populace. Education. Clarity of the proposal and its message. And a good referendum process. Now, I didn't always support the elaborate approach proposed by the panel. I was rather a minimalist to start out in this process, because I thought it had some dangers in it, and I would have preferred a more incremental change. But what I think they've suggested, the 5 points I outlined at the start of this address, I think it's achievable if we do the right things and we learn from our history. And of course the panel also recommends, has a view that coincides with me, that we should run this as an independent referendum, not in association with any other event, including a general election, but in particular the referendum on the recognition of local government. And I think, the proposals aside, we as a nation need to drag ourselves and our constitution into the 21st century, both in our thinking and in our constitutional arrangements, and in the particular way we accommodate the developments and the protection and recognition of rights and interests of Indigenous peoples, particularly through the United Nations system and other international forums. And I think, we have to, in pursuit of this, dragging this thing into the digital age, we have to abandon the thinking of the old settler colonial societies and come with a good heart to the task of resetting the relationships between Indigenous Australia and the rest of Australia, and complying to what is now a global standard. And I think the new proposed Section 116A is a very positive step in this direction. Now, the panel's recommendations to remove from the Constitution Section 25 and 51 and 26 to 21, I think is well overdue, and is perhaps the most substantive change proposal in the whole report. But it will rid us of racially discriminatory provisions that are embedded there. And I think if we adopt, as I hope we do, a new Section 116A, it will cast out forever the dead legal and policy corpse of white Australia. I agree that the Constitution should prohibit racial discrimination. But as for all referenda, we have to be mindful about the timing. And we should not underestimate the impact of the lack of priority given to this by the legislature and the executive. And the excessive deference to those two arms of government by the judiciary, which often interprets it so as to march in step with policy and legislation rather than offer a critique of it in light of international standards, perhaps with a few notable exceptions. Now I need to wind up, so on a final point, I believe that part of the problem, as I see it, is that we don't have a culture or environment for regular examination of our constitution by the people to determine if all the provisions in it still does the job effectively for us. You know, it's a pretty dead document in public discourse. It's not a barbecue stopper. You know, we don't walk around with the Senate's pocket version in our back pockets. Just wanted to raise this with you, Bill. Section 25, you ever looked at that? Yeah, of course I have. You know, it should go. Oh, good, tick that off. You know, and part of what the expert panel did when they did surveys, they illustrated how little we as people, unlike the Americans, for example, as perhaps the other extreme, we're at one end of the pole, they're at the other. A lot of Australians have no idea. The people don't even, a huge number, a majority don't even know we have a written constitution. You know, a poll was done a few years ago that a majority of Australians believe that our constitution allowed us the right to bear arms. Been watching too much telly or something, but you know, this is shocking, I think. So I'm not a constitutional lawyer, but I'm interested in the Constitution. I'm very interested in this proposal for a referendum. But we simply don't know. We don't know if it's fair, don't know what's in it. And moreover, a lot of people, the expert panel relied on news polls during their work. Encouragingly, a big majority of people said we should have a recognition which we can build on. But a majority also didn't know about this proposal. And of course, the general ignorance around. So there's a lot of work to do. So, you know, we need a groundswell of support, and that's going to be built. I welcome the fact that the federal government's funded the public awareness and community support program to engage and educate people about the importance of constitutional recognition. And it's also timely to remind ourselves of the 44 referendums in Australia. Only 8 have been successful. And the last successful one was 34 years ago. You know, there are people in this room who weren't even born yet. And we, as a result, because this document is almost impossible to change, requiring it's the only legal instrument in the world, I think, that's almost impossible to change, because it requires a double majority as part of it, and it requires bipartisan support, you know, or cross-party support for it to get through. But, and we are, as a nation, accustomed to defeat when it comes to the referendum. But, you know, like a good footy side, we should learn from our defeats and get it right next time. And really important to get it right this time, because we can't afford a loss. It'll be devastating to us, and devastating to reconciliation, devastating to the relationship between Aboriginal and Torres Strait Islander Australia and the rest of Australia. And so I'd like to conclude by quoting a passage from the expert panel's report. And I'd ask you to contemplate this. In a country that takes pride in its liberal and democratic traditions, it is surprising for many to learn that the birth of the nation was attended by racially discriminatory sentiments and continues to contain racially discriminatory provisions in its constitution. Thank you. But we have legislated to prevent racial discrimination, and it's failed us. Because we leave it to the judiciary to interpret the legislation, and we leave it to politicians to restrict its protections. And at a practical level, you can still do racially discriminating things like the Northern Territory Convention. You can still do, as far as our constitution is concerned, you can still treat refugees in an inferior way. We've tried legislation, it doesn't work. We have legislation abounding through the states, territories and at the Commonwealth level that are meant to protect, recognise and protect the human rights of all Australians. The politicians just can't do it. We need the people, in a statement from the people, to put it in the constitution that the politicians can't touch. That's I would prefer the judges with this than the politicians. When it comes to human rights, don't trust the politicians, because they'll put him aside. He's no longer a politician. And he tried to do something about human rights. He's got the charter up here and ACT. But, don't trust the politicians. We need the independence of the judiciary is where we ought to be dealing with these questions of human rights and fundamental freedoms. If we were fair dinkum about our international commitments, instead of pandering, we wouldn't have these so-called problems about both people. We wouldn't have the so-called problems of, I'm not saying recognition and protection of human rights is going to do that alone. It has to be lined up with a number of other ducks. But we've tried to legislate, and it doesn't work. The two states you mentioned have riders, disclaimers, qualifiers, this is probably the word, in their constitutions that the recognition is of no legal effect. I'm not suggesting we have one of those in the federal constitution. Otherwise, why do it? Why have they done this if they said it means nothing? What's the point? It's a waste of bloody time. On your question about refugees, the answer is no. I don't think the two major parties will reach an agreement about this. And they're both visibly demonising the Greens now. My view about the refugee, the rights of refugees, they have a right to flee persecution and possible death because the situation's home. We've signed an international treaty to that effect that we're supposed to look after until their status is properly determined, or until peace returns, or whatever that calls it. They're fleeing their countries. We haven't honoured that. My view would be to adopt Malcolm Fraser's approach to this question. The way in which he dealt with people fleeing Vietnam and again that was after a war that we're involved in. It's not as if we're got nothing to do with many of these refugees, that we have no accountability, no responsibility to. Some of them are fleeing wars that we're involved in. There are three questions in one there. The answer to the first two parts is as long as it takes. If we need more time, we'll take it. In relation to the last question, I think the government should accept the recommendations of the panel without change. Well, Mr. Abbott claims support for it. That's his public position. I've taken him on his word. I'll just outline some results of the news poll that says people aren't aware of it. I mean, there's big support. I think it's 68%. I forget the figures, don't take me, but it's that order that say something ought to be done to recognise Aboriginal. I mean, that's a huge thing to do. It's a huge number to do. You're nearly at a substantial majority.
Majority of states.
Yeah, and the government has agreed to fund an education awareness raising process. And if it takes us more than 2013, then it takes us more than 2013. We've got to get it right because it'd be a dark disaster, you know. It'll set back relationships with generations. And I'm horrified at trying to think how many generations that might affect. I'll take it as a comment, but you know, Indigenous affairs in this country is a clear learning place for not learning about your past mistakes. We know it full well, we Indigenous people, because they keep doing the same bloody thing generation, 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 and ignoring important things like self-determination, empowering people, giving them particularly control over the decisions about their day-to-day lives. That's not possible for many of us.